Money Radio, thank you for joining us. Time now to talk real estate with Laura Bramnick from TalkRealEstateAZ.com. Laura is an attorney. She's also a real estate agent. Laura can help you negotiate residential, commercial, or land transactions. Laura holds an active Arizona real estate license. She's also licensed through the State Bar of Arizona, specializing in real estate. She is also a certified instructor with the Arizona Department of Real Estate. And for more information, visit the website, TalkRealEstateAZ.com. That's TalkRealEstateAZ.com. Phone number 480-624-2705, 480-624-2705, and Laura does answer her own phone.
I do.
Hi, Laura.
Hi, Sinclair.
How are you today?
I'm doing very well, thank you.
Good. Today I'd like to talk about a subject that I think confuses a lot of people. But it's very important when you're buying or selling real estate to understand how the title to that real estate is held.
Yes, there are a lot of choices, and you want to be sure you understand what the consequences are of your particular choice. You know, whether it's tenants in common, joint tenants with the right of survivorship, community property with the right of survivorship. There's different kinds of deeds, and there's deeds that include life estates, so you want to just, they're not that difficult to understand once somebody sits and explains it to you.
Now, for a married couple, typically in Arizona, Arizona is a community property state.
Yes.
Typically, a married couple would be looking at community property.
Yeah, community property with the right of survivorship.
Right.
And many people make the mistake of doing joint tenants with the right of survivorship, even though they're married, because they feel that it's really the same thing. But the difference is the tax treatment when one party dies.
That can be a big difference.
Yes, because if you have owned property for a while and it has appreciated in value, when you do community property with the right of survivorship, let's say I bought a property for $100,000 and it's now worth $300,000. If I own his community property and my husband dies first, I then get what they call stepped up basis, so that when I go to sell later, I start at $300,000 as my basis, not $100,000, which means I do not have to pay capital gains on the $200,000 difference.
Big difference.
Big difference. And, you know, so you want to be careful about that. If you own as joint tenants with the right of survivorship and you're married, you're missing out on a tax benefit.
But for people who are not married and own property together, joint tenants with right of survivorship might be a way to go.
Yes, because the survivor inherits the entire property, and it does not have to be submitted to probate. So just with basically one simple sentence in the deed that says joint tenants with the right of survivorship, you can avoid probate.
A lot of times, I think people try to put their children on title as joint tenants with right of survivorship in order to avoid probate.
Yes, and that is one way to do it, but you may be giving up the ability to take them off title if you change your mind, or change the title in certain ways, even sell the property if you want to sell. Because when you have joint tenants, one person cannot make the decision for all the owners. You know, if there are two people, if it's you and your child and you want to sell and they don't, you can't just sell without their signature. So that would require, if you can't come to an agreement, it would require a lawsuit called a partition action.
You really do have two owners at that point.
Yes, and if a client comes to me and they say, well, okay, I want to make sure my child gets the property, then I would say, then do a beneficiary deed.
Yes, Arizona has what's known as a beneficiary deed.
Yes.
To avoid probate.
To avoid probate, and it means that if you decide to sell the property before you die, that's fine. If for some reason, let's say that your child gets married to a criminal or some kind of an element that you don't want to get part of your estate,
A ne'er-do-well.
a ne'er-do-well, you can actually record a revocation of the beneficiary deed. So once you do it, you're not bound forever. And it gives you a lot more flexibility and accomplishes the same thing. It accomplishes giving your property to your child or whoever you choose and avoiding probate.
And it's a pretty simple way to go, the beneficiary deed.
Yes, and also inherited property, you don't have the tax consequences that you do if it were joint tenants.
Again, an important point, the tax consideration there.
So you want to, the best advice that I can give, and you and I've talked about this before, is you don't want to do it in haste. You don't want to rush it because there can be consequences down the road that you're not aware of. And it's easy enough to figure it out. Take the time to talk to a lawyer, talk to the title company. Most of the time the title company will give you the definitions, but they won't discuss any legal issues with you. Talk to your accountant. It can, especially if the property has increased a lot in value.
Right.
Or you think it may, commercial property. People inherit all kinds of property.
And there may be a time when joint tenants with right of survivorship is appropriate.
Yes, maybe your daughter moves in with you and she's helping to pay the expenses. You want to make her a joint owner. And then she can always, you can always figure out the tax consequences at that same time. Figure out how long you're going to hold the property, what the taxes will be, and come up with a plan. That's the real issue. It's not that there's good news and bad news. You want to know what you're signing, you want to know the consequences, and you want to come up with a plan.
The important thing is to have a plan and to understand what you're really looking at.
Yes.
And consider all your different options. Something may work very well for you, something as simple as a beneficiary deed.
Yes.
Other circumstances, you may be looking at joint tenants, and you just need to understand thoroughly what that means. And as you say, a title company can't give advice on that.
They cannot give legal advice.
You can.
I can.
You're an attorney.
Yes.
And you specialize in real estate.
Yes.
And you can help with the transaction itself because you're a real estate agent.
Yeah, if you inherit property and you want to sell it, I can represent you through the whole transaction.
And it's like a twofer.
It's like a twofer, lawyer and realtor.
Laura Bramnick from TalkRealEstateAZ.com, TalkRealEstateAZ.com, or call 480-624-2705. Remember that number, it's 480-624-2705. Thank you, Laura.
Thanks, Sinclair.